Hello, good evening everyone. Thank you so much for joining us today. I'm Shreya Tripathi. I am a senior resident fellow with the Jaldi initiative at Vidhi. On behalf of the entire Jaldi team and Vidhi team, thank you so much for joining us for the session on shaping justice, insights into the constitution benches in the Supreme Court. I'll just give you a quick rundown of how the evening is going to go. We'll start off with a presentation on the constitution bench work that Vidhi has been doing currently, go into a panel discussion with our panelists, and then finally end with a question and answer session. Um, so without further ado, I would like to invite Jyotika, research fellow with the Jaldi team, to start the presentation.
Thank you so much, Shreya. So before we begin the discussion with our panelists, I would just like to take everyone briefly through the work that the Justice Access and Lowering Delays in India initiative has undertaken on the functioning of constitution benches. Okay. To give context, constitution benches are set up by the Supreme Court of India to decide substantial questions of law as to the interpretation of the Constitution under Article 145. They require a minimum of 5 judges on the bench, but have had as many as 13 in the past. Constitution benches settle key questions of individual and collective rights. These cases have included Keshwananda Bharati versus State of Kerala, which established the basic structure doctrine in 1970, to the more recent cases like Navtej Singh Johar, which decriminalized homosexuality in India. Considering the seminality of these matters, it is not just the jurisprudence produced by these benches that need to be studied, but also their functioning. In line with Jaldi's mission to study, understand, and solve systemic issues in India's justice delivery system, we have undertaken 2 key data-driven projects on the functioning of constitution benches. The first is the Constitution Bench Pendency Project, which started in 2022, and the other one is the Constitution Bench Time Tracker. The Constitution Bench Pendency Project is a comprehensive tracker of all pending 5, 7, and 9 judge Constitution Bench cases before the Supreme Court of India as on 10th February 2025. It aims to serve as a one-stop source on all pending Constitution Bench matters before the Supreme Court. And it hopes to achieve that through 2 key features. One is comprehensive summaries, and the other is aggregate statistics. The summaries capture information like facts, questions of law, along with the status of bench constitution, that is whether benches have been constituted or not, and provides date and reason for reference, etc. We have also recently added the aggregate statistics feature to the portal, which provides information on not just the total pending main and connected constitution bench matters, but also on the average number of days that these matters have been pending for, as well as the stage at which they are pending. For instance, our portal shows that as on 10th February 2025, there are a total of 28 main and 246 connected constitution bench matters pending before the Supreme Court, out of which a bench has been constituted in only 1 case. That is a 5-judge bench case looking into the question of whether the courts have the power to modify the arbitral awards. On average, these cases have been pending for a whopping 2,413 days as per the data that we have, which is around 6.6 years. Out of this, the oldest pending case is a 7-judge bench case called Arjun Flour Mills versus State of Orissa that has been pending for more than 25 years from the date of its reference. Now, in order to understand the workload of the constitution benches of the Supreme Court, it is important to not just look at the pendency in numbers, but also the time that constitution benches require to hear and dispose of these matters. And therefore, our second database on constitution benches tracks the time spent by the Supreme Court in 5, 7, and 9-judge bench hearings from 27 September 2022 to 31st December 2024. The tracker originated from a need to understand how the Supreme Court allocates its time in Constitution Bench hearings. We were able to do this with the help of the Supreme Court live stream recordings, hearing transcripts, and court orders. For each hearing in a case, we analyzed the live stream recordings to calculate the time spent by the advocates in their oral arguments. The cumulative hours spent on all oral arguments in all hearings in a case was considered to be the case time. Since the tracker relies on live stream recordings, our dataset spans from 27 September 2022. It consists of cases that have been fully live streamed and were either reserved for judgment or disposed of as on December 31, 2024. For this purpose, we have excluded hearings where judgments were pronounced and no oral arguments took place. In all, our tracker records information for 23 cases, which are 16 5-judge bench cases, 4 7-judge bench cases, and 3 9-judge bench cases. So how much time have the advocates actually taken? Our database records argument time of a total of 179 advocates across 23 cases. Out of this, the table presented lists the names of the advocates who have logged the highest cumulative hours of arguments. Naturally, the Solicitor General, Mr. Tushar Mehta, appeared in the most number of cases and argued for a total of 57 hours while presenting his arguments, followed by the Attorney General, Mr. R. Venkataramani, who appeared in 13 cases and logged a combined 29 hours of oral arguments. While it may seem excessive, the average time for both of them comes about to be 3.6 hours and 2.2 hours respectively, which is significantly lower than what some of the other advocates like Abhishek Singhvi and Rajiv Dhawan have taken. Now, if you look at the list, you can also see that female lawyers are conspicuous by their absence. And that is not just the case in the list itself. Our data shows that out of the 174 identified advocates who appeared in the 23 cases, only 29 were women. While male advocates argued for 96% of the case's total hearing time, female advocates were heard for 4% of the time. Moving on from individual advocates, how much time does the SC actually spend on Constitution Bench cases? Overall, in the last 2 years, our data records that 5-judge bench hearings have taken on average 15.6 hours, 7-judge bench hearings have taken on average 14.5 hours, and 9-judge benches have logged the highest amount of time at 24.9 hours on average. In terms of judicial time, however, that is the number of judge hours spent on these cases take 5, 7, and 9 times the average case time, depending on the bench composition. Again, while this may seem excessive, it is imperative to understand that these benches decide some of the most complex questions of law and may actually need this much time. So who are the judges deciding these cases? Our tracker also provides information on the judges who were part of Constitution benches. As can be seen, the ex-CJI, Justice Chandrachud, was part of the most number of benches at 16, followed by Justice Manoj Mishra, Justice Pardiwala, and so on. The CJ has historically sat on 77% of the benches. During ex-CJI Justice Chandrachud's tenure, this figure, however, increased to 100%, as he was part of all the benches that he constituted as the CJI. This assumes a particular significance because as per a study conducted by Mr. Nick Robinson in 2009, in any given vote, the chance of a judge dissenting reduces from 5.2% to 0.8% if the CJI is present. In Justice Chandrachud's case, he was in partial dissent in only one of the cases, that is the same-sex marriage case during his tenure as CJI. So considering that CB decisions significantly shape the social, legal, and political landscape of the country, it is necessary to not just look at the jurisprudence produced by these cases, but also the functioning of these cases to gauge the efficiency, diversity, and representation involved. We hope to continue adding to the discourse through our work with the Constitution Bench Pendency Portal and the Constitution Bench Time Tracker. Thank you.
Thank you so much, Jyotika. Thank you for laying down the groundwork for the discussion that we are going to have today. We are looking forward to deep diving into some of the issues that we have figured out and seeing what are some of the causes behind them. It's my absolute pleasure to invite our esteemed panel for the discussion today. Joining us today are Ms. Aparna Chandra. Aparna is a professor of law at the National Law School of India University, Bangalore. Aparna researches and writes on constitutional law, human rights, gender and the law, and judicial process reform. Her most recent contribution to the field is a co-authored book titled Court on Trial, a data-driven account of the Supreme Court of India. Also joining us today is Ms. Jaina Kothari. She is a senior advocate at the High Court of Karnataka and practices before the Supreme Court of India. She is also the co-founder and executive director of the for Law and Policy Research in Bengaluru. Her areas of expertise and interest include public interest law, constitutional and administrative law, social rights, disability rights, family law, consumer rights, and property law. Also joining us online is Mr. Nick Robinson. He has written extensively on courts, judicial processes, the legal profession, and human rights. He has taught at the Jindal Global Law School and National Law School, Bangalore, and clerked for the Indian Supreme Court. His work has been published in a number of leading law reviews, including the American Journal of Comparative Law, Duke Law Journal, and Cornell Law Review. Also joining them to moderate the panel is Ms. Shruti Nayak from the Jaldi team. Please welcome to the stage.
Thank you so much, Jyotika, for setting the context for this decision and discussion and telling us what constitution benches do and how they function at the moment. We're very fortunate to have with us this wonderful panel with us today who bring a wealth of experience. We have Aparna, who's a professor, of course. We have Jaina, who's been practicing before the Supreme Court. And we have Nick, who's been writing about the functioning of the Supreme Court for a long time. So I think this discussion is going to definitely be one which everyone will have a lot to take back from. So given the context that Jyotika has set in terms of what constitution benches do, I'm going to kickstart the discussion with one of the points that she made towards the end of her presentation, which is the advocates who appear before these benches, right? And maybe Aparna, I'll start with you. So prior works, including your work, your book, Court on Trial, as well as works that Nick has written, has spoken about how access to the Supreme Court is mediated by access to an expensive lawyer. How do you think this has worked historically? Has this always been the case, or is this something that has only occurred in the recent past? And also, do you think that this is something that hinders one's access to the court itself?
Thanks. I would first thank you for having me, and happy to join old friends on this panel. I should just add that Vidhi, of course, has also done a lot of work on lawyers who represent clients before courts and win rates of senior advocates versus others. Historically, yes. I think world over, and particularly definitely in the common law system, one of the challenges of the common law system has been that access to courts is mediated through lawyers, and then the better the lawyer that you can hire, the better your chances to to have your day in court or win out in court. So yes, that's been the case. In fact, in Keshwanand Bharti, which was up there on the screen a little while ago, one of the judges mentioned that, one of the criticisms of the court in that time was that it had become an arena for the legal quibbling of men with long purses. And it was exactly this idea that this is an elitist court. Access to the court is only for the rich, and that the court is not involved into the lives in the day-to-day sort of injustices faced by the common person. The court has tried to change that, and in the 80s it tried to change that. But our work has shown that at least when it comes to the question of getting access to the court and having your day in court, senior lawyers definitely end up skewing the result. Might be for good reason. They are senior lawyers after all for a good reason. They have more experience. They might be better trained, so on and so forth. But we found, and this was the bit of a surprising finding, that while senior lawyers may end up getting your matter admitted in court at a higher rate than other lawyers, when it comes to actual merits hearing, they have roughly the same win rate as other lawyers. So our conclusion in our book, my co-authors and mine, was that there are things that senior lawyers end up being proxies for. The word that gets thrown around quite a bit in the court corridors and by judges is their face value, that judges rely on them in, they don't have enough time, they have to decide cases very quickly. So they rely on who the lawyer is very often as a proxy for deciding whether a matter should be admitted or not.
Right. And maybe that'll just take me to the question that I have for Jaina. In terms of people who appear before the constitution benches, so for all of us who are not practicing, we see a case is called, there's a flurry of advocates who head there. For cases which have many connected matters, we see more advocates who go there. So in terms of the time that we see that's allocated between lawyers, can you shed some light on how that's determined? Is this based on advocates who've decided beforehand that they're handling specific issues, or is it that someone starts and then the others add on? How has this worked?
Actually, if you're in the Supreme Court, you'll realize that there is no method to it. It's complete madness. It's just based on, it used to be, to a large extent, sometimes it still is just based on who are the lawyers with the maximum clout and maximum influence, who get to start and lead the matters and lead the arguments. And thereafter, as a few of the lawyers would lead, the court also gets tired and then requests the following lawyers to kind of cut short their arguments. What used to often happen is that it would be, most senior, most influential lawyers who would start leading, and then the lesser known lawyers, even among the senior lawyers, would then be trailing behind. The women would either not get a chance at all. If you look at some of the earlier constitutional bench cases, there were almost no women lawyers arguing. And even if they did, in the later cases, they would get very little time to argue. But you do see some change in the last couple of years as more and more constitutional bench cases are being heard. We saw that happen from Justice Lalit's time, from the end of 22, I think. And there were a lot of lawyers. The court started putting a system where they would say, let all the lawyer counsels from one side decide among themselves the order and the time taken. So that gave a bit of a chance to the lawyers to get together and ensure, that everyone gets heard at least, and then some reasonable restriction on time for some of the lawyers who would otherwise be arguing for 5 hours. Because then the court would say, well, we're only giving 2 days for petitioners, or we're giving 1 week, for 5 days for the petitioners. And if there are 5 days, and if there are 20 lawyers or 15 lawyers, then there would be some reasonable allocation so that even the younger lawyers or all lawyers basically get some time. And we saw that happen in the marriage equality case and some of the later ones, and that. But then that's an ad hoc arrangement. Not all benches do that, but they've started doing that. And that has actually proved to be a good system. But then it's not always implemented very well. The ones who start, even if they have a time of 2 hours or 1 hour, they outshoot their time. There's no one to tell them. The court knows about this time, but they don't stop because they get away because they're very senior and have a lot of influence with the court, and that then cuts short the time of the ones later in the list.
Right, so just a follow-up on that. So considering that you're saying it's largely ad hoc, it depends on the members on the bench at the time. Do you think it's possible for us to institute a sort of system where some sort of rationing would be possible? Do you think that that's feasible at all?
I think it's definitely feasible. I mean, the court can certainly fix, a fixed time for the hearings, fixed number of days, which it is doing in some of the Consti bench cases. But it can also fix some time limit on counsels arguing. Definitely. Um, I don't see any reason why it can't. It has been doing it in some cases, but we see that, the court judges find it increasingly difficult to do it with the lawyers who are there in court for years and years and are the well-known seniors, most often the senior men, and they're unable to keep the timeline. Often because the judges are themselves younger than some of these senior counsels, and they have a big hold over the court. And they do it, and therefore they try and compensate by putting those restrictions, which they aren't able to insist with the senior lawyers on the younger lawyers. So we see that happening. But yes, definitely. I mean, why not? In the US Supreme Court has a light, it has a bell. I mean, why not? I'm sure the rest of the arguments can be put in the readings, in the pleadings, and you just focus on what you want to submit.
That's definitely an interesting way to think about how we can change the system from what it currently functions like. And that brings me to Nick. Maybe I'm just going to ask you a bit on like zooming out broadly into constitution benches at the Supreme Court itself. Your previous work has shown us that the most number of benches that were there was in the period of 1960s to 64, and it's largely fallen ever since. And of course, we've seen a slight rise in that number during Justice Chandrachud's term, which we've seen like 16 cases being there. But overall, based on your analysis on the workload of the Supreme Court, what do you think led to the filing of more cases at that time? Or rather, why did we have more constitution benches at that period of time? And what do you think impedes the setting up of these benches in the present day and its impact, the impact that we have due to these delays?
Yeah, thank you. And thanks for inviting me and organizing this. And it's really nice to be amongst old friends and colleagues on the panel, and I'm sure in the room. So you're right. So in the first part of the 1960s, the Indian Supreme Court was hearing over 100 constitution benches a year on average, and that was with a much smaller court. So the court was about 14 judges at that time. And even that was a relative decline. When you go back into the 1950s, the court, more than 10% of regular hearing matters were constitution bench matters or 5-judge or larger bench matters. And I think, part of that was also just there was a different understanding of when you constituted a constitution bench. So back in the 50s, if you were challenging the constitutionality of a law, the lawyers, the judges, everybody knew it went to a constitution bench. Really just for constitutional issues more broadly, these went to constitution benches. And then by 2000s, though, you have, less than, and starting in the 80s, going into the 90s, 2000s, you have less than 10 of these benches on average being heard per year. And, on average, this is less than 0.2% of disposals up until at least recently. And I guess the question, as you're saying, is like, what happened? And what's striking to me is first of all, what did not happen. There was no change in case law. It's not like the court came up with a seminal decision that said we're going to hear fewer constitution benches for this reason or that reason. But instead, we saw this massive increase in the caseload. You have all these SLPs coming in. You have thousands of admission matters coming in. You have this kind of promiscuous understanding of like what cases should be heard by the Supreme Court. And the court, frankly, just becomes overwhelmed. You see these mounting delays. You see judges fixating on these delays. You see chief justices judging their tenures upon, how much they can get these delays down. And so you have a move first to 3-judge benches and then 2-judge benches, right? Which then become the norm of hearing all of these matters. And I think the point here is that, it was kind of not really a thought through move. So, there's that old, I forget who said this, but that the British Empire was created kind of in a fit of absent-mindedness. Well, it's was kind of a fit of institutional absent-mindedness that created the sprawling Supreme Court we have today. And I think, when you're thinking about this, you want to think about, what should the Supreme Court do? Be intentional about it. Like, when should you have constitution benches? What's the most beneficial structure for the court and the best use of judges' time? Not for the court, not for the lawyers, but for India, right? Like, what's the best use of the court? And then try to craft an institutional design in response.
Right. So when we talk about, and you mentioned a good part of this also comes down to the constituting of these benches itself. And perhaps, Aparna, I'll just turn back to you again. Of course, the bench composition is determined by the CJI. We've often seen that some judges tend to sit more on constitution benches than the others. So what are the considerations that need to be balanced in your view when setting up these benches? And do you think having a technologically driven solution to case allocation is a good way to go?
Right. So I think there was some mention of the fact that historically chief justices have sat on about 77% of the benches that they have themselves constituted. And just to put this in perspective, that's 4 times the number of benches any other judge sits on. So chief justices who do the assignment to constitution benches over-assign themselves. Historically, from 1950 till date, chief justices who have, remember, constituted these benches have been in dissent only 13 times. And I'm counting this partial dissent of Justice Chandrachud in the marriage equality case in that, in the thousands of constitution benches that have been there. So the benches that they constitute, turns out, tend to side with chief justices, right? And leads to the somewhat obvious inference that when chief justices are constituting these benches, they're constituting them also with an eye to outcome, because you don't see similar patterns in any other bench structure, right? Or in benches where the chief justice is not present. So that is a big concern. Now, how are they constituted? We don't know. Right? It really depends on who the chief justice decides to put on the bench. There is no seniority norm. There was, if you recall, in 2018, when the 4 judges, senior-most judges after the chief justice came out and did a press conference about the Judge Loya case assignment. And, there was an implicit understanding that while the chief justice was the master of the roster, that's the technical term, and therefore could assign the case to whoever the chief justice wanted, it was unheard of that these important matters, strategic matters, were being assigned to a relatively junior judge. So we looked at that. We looked at whether seniority explains who gets on to be on these benches. And seniority does not explain this at all. In fact, if you look at Justice Chandrachud's tenure, for example, there are many relatively junior judges. I mean, we are still talking about people who've been judges for a really long time and they're in their 60s, but relatively junior judges who are over-assigned or are assigned repeatedly onto constitution benches, whereas their more senior colleagues are completely sort of out of these constitution benches. Chief justices have refused repeatedly on the judicial side, on the administrative side, to give any kind of standard or framework for how they will assign cases and when they will assign cases, right? So when they will list these matters. And that means it depends absolutely on the whim of the judge, not just who gets to be on the bench, but when the bench is actually set up. So this goes to the idea that there are 28 pending matters, but only one in which a bench has actually been constituted.
And I'm just going to go to Jenna with a similar question. So, of course, one of the methods that people suggest are computerized allocations of cases. Another suggestion that a lot of people often make is the setting up of a permanent constitution bench. What do you think are the pros and cons of having these sort of mechanisms to reduce the amount of discretion in setting up the benches?
Thanks. I'll just actually answer that, but I'll continue a bit from what Aparna said. I would I would disagree a little bit about the complete ad hocness. Yes, it is completely in the hands of the Chief Justice, but we see that before Chandrachud, the whole spur of really reviving constitutional benches was by Justice Lalit in the end of 22. Because before that, there were just basically 3 or 4 consti benches being decided a year. And it was really Justice Lalit who completely pushed and revived constitution benches sitting. There's actually a great analysis on the Supreme Court Observer on, on the master of the roster and constitution benches. And I take a lot of my data from there, written by Sudhir Krishnaswamy and Advay, who's here. We see that Justice Lalit actually had a system, or at least he tried to follow his own system, where all the senior most 6 judges all headed a consti bench. And he followed that, and he ensured that each of the 30 judges sat on one bench at least, one consti bench. So, of course, even within his roster, there were some judges who sat more than others, but at least he followed some sense of seniority where each of the senior most judges headed one bench. He was not on every bench. And all the judges got a chance to sit on the bench in a constitution. And we see that with DYC, it completely changed. He was on all the benches. And if you just look at the article also has the number of cases, a number of benches. And you see, like you said, fairly junior judges during Justice Chandrachud's tenure sitting on number of cases, like Manoj Mishra was on 16 benches. Justice Pardiwala was on 12 benches. And if you see, and then there were others like Justice Sudhanshu Dhulia in 1, Dipankar Datta in 1, with absolutely like no basis. You see the women judges completely sidelined. Justice Hema Kohli in just 1 matter, I think it was a marriage equality case. Justice Bela Trivedi, I think in 2 matters, and Justice Nagratna in 3. I mean, she was also on the 9-judge bench. But you see that it's completely ad hoc, and then there are some judges who are just sitting all the time. And I'm not sure if I would agree with a technological solution, because I don't think it has to be completely random or, with the non-human involvement. I think there is a need for an involvement. For example, you may say it should be headed by senior most judges. Do senior judges get more of a chance to be on consti benches than the relatively junior ones who may have a longer tenure? Then what about subject matter expertise, right? You do have judges with certain subject matter expertise. If it is an arbitration matter, it is useful to have judges on the bench who have an arbitration experience. And you do find that that is actually sometimes being ignored. For example, in the arbitration consti benches, Justice Oak, who has an arbitration roster in many matters, is not on that bench. So we find that what about personal law matters? If there is a bench on a personal law matter, or a family law matter, like, there was a bench, I think, on the restitution of conjugal rights challenge or divorce, you don't find judges who have that experience. It need not be just women judges. I mean, you don't find judges who deal with personal law matters on that bench. So I think subject matter expertise needs to be taken into account. Seniority, for example, needs to be taken into account. Some diversity needs to be taken into account. Tenure perhaps needs to be taken into account. So for that, you need a human intervention, but you need some procedure. And maybe we need to lay down some guidelines which take some of these things into account.
So just to say, I forgot to answer that part of your question. 2 points. One is a clear default rule, and then when will the exception be triggered, right? And whatever that default rule is, it could be seniority, it could be subject matter expertise, whatever it is, it should be a clearly stated default rule. And then if exceptions have to be made, then they should be clearly communicated that there are certain reasons why these exceptions are being made. So that is one thing. But I think this, just to relate this back to something that Nick said, there's a larger problem here, which is the declining constitution benches, where courts are not hearing constitution benches or not setting up constitution benches at all. Even again, our data shows that about 78% of all constitution challenges in the Supreme Court are actually decided by 2-judge benches. That's because constitution benches are not being set up at all. And again, there's been a relative uptick, but it's nowhere near the heydays of, constitution bench matters in the first 25 years. And this is just to say that when we look at this number of 28, that might be misleading. Right? That these are the cases which have been sent to constitution benches. What about all the constitutional challenges that have not even at the court? My own suggestion is that it is not so much a permanent constitution bench, but a constitution division to the Supreme Court that makes more sense. And then, if you can have a corporate, a company company matters division in high courts, commercial matters, commercial courts, and commercial divisions in high courts, why not think of a constitutional division? What that would do, most importantly, is insulate the constitutional function of the court from its everyday appellate function. It's the same court, but in that court, if you have a constitutional division which is just focused on constitutional matters, then some of the excessive delays that you're seeing of 2,000 odd days on average, and running up to 25 years, that kind of delay and perhaps that kind of evasion that the court often does might be difficult for it to do.
For sure. And I think that gives us the perfect segue into my next question to Nick, actually, which was, I know like permanent constitution benches is of course one suggestion, but your recent paper that you've written with Jyotika also talks about having a constitution bench for admissions, like an admission constitution bench. Can you share a little bit more on your thought behind why that was a suggestion? And also, would it not run into the same problems that everyone thinks about when we think about constitution benches in terms of, okay, it takes this much amount of judges to sit and we don't really have the time to take away these many people from our existing capacity?
Thanks. Yeah. And so this is coming out of a paper that, as you said, Jyotika and I wrote, that's coming out in the International Journal of Constitutional Law, which has kind of the title, deciding how many judges should decide, right? So the title really says it all, which is a thinking about how many judges should decide what kinds of cases, looking at constitution benches, particularly on the Indian Supreme Court. And I think core to that, just to provide a little context to this proposal that we put out, is that there's really kind of 3 types of institutional factors that determine when larger benches are constituted. And then we propose reforms to all 3 of those factors. And I think it's important to think about this kind of holistically and not just any one of those factors. So for example, one of the factors, we've already touched upon, which is like, just what's the substantive criteria? Like, when should these benches be constituted? This has been pointed out before, but there's never been a constitution bench on when constitution benches should be constituted, like how to interpret 145.3 of the Indian Constitution. And you have a lot of different inconsistencies in terms of how it's been used. And so, we can think about like, what's that criteria? What are these kinds of quote unquote important cases that should be going to constitution benches? And then, but second part of that is not just what's the criteria, but like applying that criteria. So, and this is where this proposal comes in. And currently, I think most people think there's really kind of an inconsistent referral system by smaller benches. And you also have a system where, this came up in Jyotika's presentation earlier, it takes so long for a case to make it from a smaller bench to a constitution bench. I forget what she said, 6 years, 5 years, whatever it was. There's a real incentive for everyone to try to just get the case decided by the smaller bench, including by the judge, not to refer it forward. And so I think, any system you're thinking about, you want to create more consistency and more cases ending up as to constitution benches. And so this is the idea of the dedicated admission constitution bench, or a 5-judge bench that would just be thinking about this. And it would be an opportunity for litigants themselves to directly approach this when they think they have a case that should be getting heard by a constitution bench. And I think this lines up with Aparna's idea potentially as well of just having a division. You have judges, you can kind of skip the smaller bench, right? So that it speeds up the system. But you also, in theory, will have these judges thinking about what kinds of cases should be going to constitution benches and creating kind of a more systematic and uniform approach to constituting constitution benches. And again, this doesn't have to be the only approach, but I think, it's an idea about how to create a forcing function to a system that isn't having the consistency or the number of benches you'd like. And so it's kind of an institutional intervention there. And then to kind of go to your other question, which about capacity, which is kind of the third institutional factor you have to think about in, when these benches are not getting constituted. Obviously, when I started talking, the whole reason of decline was because of hearing so many SLPs and ordinary matters. And so there's this question about judicial capacity. And so one way to get more judicial capacity to do this is to just hear fewer of other types of cases, kind of more ordinary matters. You can also think about getting rid of oral admission matters, right? Right now, that takes up a lot of the court's time. That's been pointed out before as an area where perhaps the court could be saving times and resources. And then, and even when you think about like all these cases that are being heard, I thought Green and Yoon has this article, out about, most Supreme Court decisions are just never cited, right? In fact, many of them never cite a single other opinion, right? They're just cases that are just sitting there in and of themselves and really have no relationship to the rest of like Supreme Court jurisprudence. And then you just have to ask yourself, is that a good use of the court's time? Could it be doing something better? If we all think there should be more constitution benches, and these are by definition important cases, the most important cases, right? Then maybe it's worth the court's time to, dedicate more resources over there. And, this is a court that now has a sanctioned strength of 34 judges, right? Like that's far more than it had historically. That's more than, many of its peers around the world. So to say that there's not enough resources to do this, I think isn't the right way to approach it, but instead, like, how do you want to allocate those resources? And so again, this was a proposal from Jayotika and us about, a forcing function into a system that seems to have institutional drift and, hasn't necessarily kind of thought through in an intentional way what kinds of cases to prioritize.
Thank you for that, because I think one of the points that you mentioned is perhaps one way to do this would be to reduce the oral admission matters, right? And perhaps I'll take that question to Jana. From your view as a practitioner, of course, people make suggestions saying, in order to maximize the judicial time that we have in the few hours in court, greater reliance should be put on written submission and lesser on oral submissions. What do you think about that as a suggestion, especially in the context of constitution bench cases where clearly different people could be coming at the issue from different lenses, right? And it needn't always be that everyone's looking at a matter of interpretation from one point of view. So do you think it would be feasible for us to have a system like that in hearing these cases?
No, I agree that a lot more emphasis on written pleadings could definitely be made, and that would free up the court's time for, for constitutional bench matters and just clearing the pendency. But I think it may not, I wouldn't say that we have to do away with oral hearings, maybe oral admissions. No, there is a value to it. And if you actually look at the time, the amount of time that the court would spend on admission matters, as a practitioner, I can say, the time spent on after notice matters is far more, the admission average is really just a few minutes when the court decides whether to admit a matter or to not. But the bulk of the delay is, you have matters where notice is issued, it comes up for hearing, arguments go on for an hour, it's adjourned, we have multiple such hearings, and and the matter still lingers on. And so, how do you put some system to that? How do you ensure that once notice is issued, all the pleadings are done with the registry where the court's time is not utilized, and then the matter comes before the court? There's a fixed time, there's no adjournment. If someone wants an adjournment, they do it beforehand, and then the matter is heard and there is a fixed time given and the matter is finished. I mean, this not only costs the court precious resources on its time, but lawyers as well. We are flying, going there, clients cost, lawyers cost going there, matter is either not reaching, it's taken up, there's an adjournment sought, and we're doing this week after week. And so that really is the bulk. How do you put some system into that so that it then frees up time for important larger hearings, which are also then within a fixed time frame?
Right. Just a quick follow-up on that. Do you feel that there's going to be resistance from the bar?
There's going to be a lot of resistance because this is the bar's daily bread and butter, right? Especially the Supreme Court bar. And there is going to be a lot of resistance. There's always been resistance. I mean, even the case management system in lower courts, which was there in the Supreme Court, there are decisions that there should be a case management system. Even in the district court, trial courts, we're not able to do it because lawyers are not willing to conform to that. So certainly there's going to be resistance from the bar.
For sure. And maybe just to stick to, stick to Jenna again for one more question. So we saw that there are 28 main matters pending, 246 connected matters pending. But do you think that there are any steps that the bar can take towards pushing for these matters to be heard? And are there any factors that make this difficult?
See, it's actually a little difficult. I think the one thing the bar can do is that when these matters are taken up, then to stick to the timeline and to ensure that it's actually done in a time-bound way, which even the bench now often insists on. But a lot of times when you see these old constitutional bench matters, the reality is that the matters are filed 10, 15 years back, at least 5-7 years back. When the matter comes up, really it becomes an academic legal question. And in most cases, of course, in some cases, the relevance still remains, but in many cases, it becomes an academic question. The original client is nowhere found. I'm telling you, really, the original client is nowhere found. The AOR hunts up, even in big, in matters that have a large impact. There are just one or two lawyers who are still there. They have to look for senior counsels who are willing to argue. Actually, there's a lot of interest in the counsels to argue because they get to argue before a constitutional bench. They get visibility, and you really get to make the law, right? So there's a lot of interest in counsels to argue. You do find senior counsels actually really grabbing these constitutional bench matters, but it's not the loaded matters. They are not well paid because the clients have forgotten that they have a matter which is referred to a constitutional bench. And so where is the incentive for the bar to push and get these matters heard? Once the matter is listed, there's great incentive in appearing and arguing in these matters. But the bar really, the incentive has to come from the court to say that we want to hear these matters so that they are heard when they are relevant to the petitioners in the case and also decide the question of law. But I think the buck has to fall on the court to say that how do we ensure that these matters don't linger on? You have a restitution of conjugal rights challenge, which a woman has made. Who knows what has happened to her case when the matter comes up 10 years later, then it just depends on who is available then to argue the matter.
Maybe Aparna, just to go back a little bit also on an earlier point you made, which is that it's not just 5-judge benches that are hearing matters about the interpretation of the Constitution. You said that there are a lot of cases where 2- and 3-judge benches are also doing this. So then what makes the difference? What makes some cases come up before the 5-judge benches and what makes some go before the smaller ones?
Right. So, well, our data showed that about 78% of all constitution challenges are being heard by the by two judge benches. I don't know, Nick, if you did any number crunching on that, and if so, what your numbers suggest. And the bulk of the others were being heard by three judge benches. So I did some number crunching, as I was telling you earlier, from your portal, and that seems to suggest that about 0.8% of all judicial time in court is spent on constitution bench matters, right? And these are the most important cases that the court is hearing. Ultimately, so I mean, just to say, there is a huge question about what is this court's role. It goes back to Nick's point. What is this court there for? This was never envisaged, at least in the Constitution of 1950, it was never not envisaged as a routine appellate court, right? Which is doing what we've called case by case rescue, looking at every case like it is just another appellate court. Like from the magistrate court, you go to the district court, you go all the way up to the Supreme Court. There is necessarily any question of law or anything. It's the judge thinks that, yeah, maybe I would have decided the case differently, and so I'm going to admit the matter. If that's the bulk of your cases, then we have a problem. Is that really what the Supreme Court should be doing? And so that's the larger question about what is it that this court is doing. On to your specific point of how is it that some matters land up before the before constitution benches. Generally by reference from smaller benches. So smaller benches, so when a matter is being admitted, that the bench that is admitting the matter might take a call that this involves a substantial question as to the interpretation of the Constitution, and refer it to the Chief Justice to set up a Constitution bench. A smaller bench that is hearing the matter may find that there's conflicting precedent, and generally of say three judge benches or 5 judge or higher benches, and that needs to be resolved, but this bench can't do it because it's a smaller in size bench, so they refer the matter to the Chief Justice for it to be for a constitution bench to be set up. So it's essentially through this reference mechanism. So but that essentially means that you have a two-step process, right? And this again goes back to Nick's point. You've heard this matter in a smaller bench, then the judges decide that this is something that needs to be heard by a larger bench, and then they send it to the Chief Justice, who will then constitute that bench, and so on and so forth. There might be an additional step where if it's a 2-judge bench that's doubting the correctness of or is saying that there are 2 conflicting 3-judge benches, then it might go to another 3-judge bench to decide whether there is actually a conflict, and in which case they will refer it to a 5-judge bench, etc. Right? So it's a very convoluted process, and very rarely there are circumstances, but they're very rare circumstances where the court decides, and if the matter is being heard before then it's admitted, the Chief Justice is hearing the admissions, may refer it directly to a 5-judge bench, but those are fairly rare matters.
Right, and I think that takes me back to Nick, because like Aparna mentioned, the way the process in which they come before a 5-judge bench is largely through referrals by smaller benches. One of your again, going back to your latest article where you've spoken about perhaps high courts also being able to do some of this, to be able to raise these questions, right? Can you perhaps share some of your insight into why you think that would be a good way to go?
Yeah, no, I think there's a question about how, particularly in constitutional jurisprudence, because since in India, many of these constitutional cases start in the High Court, right? And so you think about, well, you do want probably one level at least of appeal, right? Because, we'd assume at the first level, generally it gets right, is the hope, right, within the system. But we all will admit that there's some fraction of those cases that is wrong. And so you need an appeal for whatever reason, idiosyncratic behavior of a judge. And so currently, I think the Supreme Court, as Aparna has mentioned, it often has that role, right? Particularly in constitutional cases that are starting off in the High Court. And so I think there's this feeling among some of the Supreme Court judges that we need to hear this because there's no other appeal really besides us. And I think there's a couple ways you could address this. One is potentially by having appeal within the high court itself, right? Going to a larger bench within the high court for certain kinds of cases. And so you're, again, kind of pushing this down in the system. Another, which has been brought up by different academics and others and practitioners, has been having the district courts hear more kinds of constitutional matters. So maybe this isn't about the validity of a law, right? Like if you have a constitutional challenge to a law, but certainly some of the matters that involve kind of constitutional issues could potentially start down in the district court level and then go up to the high court. And some of these are practically, this is happening in some cases anyways already. And just making sure, I think the larger point is that there's at least one level of appeal before you get to the Supreme Court. Because if the Supreme Court's your only real level of appeal, then of course the Supreme Court's going to have to hear a lot of cases. Because, most systems that you look at around the world, there is at least one level of appeal for a lot of these kinds of matters, particularly if it's kind of based on the facts of the situation and applying that in. Yeah, so that's the basic idea. And in general, I think the goal is to try to push this down. And, Aparna and others have made this point as well, that, and this came up even in the Constituent Assembly debates around the Supreme Court, this real fear that too much would go up to the Supreme Court, and it gets away, that the high courts, the district courts are in better position, they're more accessible for ordinary litigants to be able to get justice, and it's less expensive for people to also approach these courts. And so the more we can kind of move this down closer to ordinary folks, then the better off we'll be as the system, but the system has to be designed for that. And unfortunately, right now, in many of these cases, the Supreme Court ends up being this first recourse of appeal.
Right. And of course, because these matters, at least the ones that come before the Constitution bench, are fairly technical, I would say, because they are contested as to their interpretation. Aparna, just wanted to understand what your thoughts are on the accessibility of these Constitution bench decisions and what they add to jurisprudence. When I say accessibility here, I also mean more specifically the length and the number of decisions that we come by, right? Because more often than not, we see multiple judgments being authored by different members of the Constitution benches. Do you sometimes feel like we ourselves have to interpret the interpretation that they are giving of the Constitution? And how does it really affect a layman's understanding of the Constitution if it's so hard for us to decipher?
I should say I teach constitutional law. And you can imagine what my reading list looks like, because a small constitution case, and I kid you not, if it's less than 100 pages, I don't provide extracts because that's a small constitution bench case. You should be reading 100 pages on your own in an hour, right? No. But just to say that it is a challenge even for lawyers. And then students often ask, what is the ratio of the case? And I'm like, that's an interesting question. What do you think is the ratio of the case? The only reason why I say this is, I'm forgetting who said it. As one of these, Mark Twain or George Bernard Shaw wrote a letter to someone and said, I'm sorry for writing you a long letter. I didn't have the time to write a short one. And I think it's something similar that's happening here. If you see a 1,000-page Supreme Court judgment, about 200 are submissions of lawyers, right? About 200 is actually a short recounting of that. 200 might be a focus on, okay, here are the large questions that this case raises. Here's what everyone in the world has said about it. Generally boils down to about 10 pages of analysis. Is my sort of sense. You could condense that to those 10 pages. And the reason why that's not happening, apart from the fact that there's now this wealth of information that is available, it's easier to get all of that, dump it into a judgment, so on and so forth, is also that judges just don't have the time to be very precise and to write to the point, right? So and that has huge repercussions. Today, what does the ratio of a case mean? What is a judgment a precedent for? Judgments say all sorts of things, right? Things about, the human condition, things about the nature of the world, things about, things about things that judges are not experts in at all. Or well, um, uh, yeah, but you can't say that, right? I was just thinking. Of course, judges are experts in all matters, but perhaps not as expert as maybe others. But just to say, I mean, the larger point is that therefore, in the next case, what do you cite this as precedent for? Right? So that becomes that's a serious question as to the nature of this judicial enterprise, right? Of precedent bound. Are we really precedent bound? It makes very little sense when judgment says so many things, they're contradicting each other all over the place, that I can read the same judgment and have a completely different takeaway from what you have, and both could be absolutely valid readings of the judgment. So definitely this has been a huge issue. There are many folks who suggest that perhaps having a whole bevy of law clerks is also contributing to it. That's bringing in a lot of research, which is good, but not as much time to curtail that and sort of have a precise judgment. That's really a problem. You can see the difference between a judgment in the 1950s, which, short, pithy, 20-page judgment that lays down a clear proposition, and the thousands of pages that you get routinely now.
And I just noticed the time. So I'm just going to go around with one final set of questions that I have for all of you. And these questions are more on looking ahead, right? Of course, we just spoke about how these decisions are complex. They're hard for us to understand. And that's definitely something that we should hopefully be able to maybe encourage people to do going forward. But Jana, I'm going to start with you on this. And I'm going to pick up on one of the points that you mentioned early on diversity. Now, diversity in terms of the bench is a fairly well-known problem at the moment, but less spoken about is diversity at the bar, right? And as Jyotika mentioned, in terms of those who appear before constitution benches also, we see very few women, and also the women have little amount of argument time compared to their male counterparts. And again, that's something that you brought up as well. What do you think contributes to this, for one? And second, what steps do you think at a systemic level can we do to encourage more representation within the bar?
So, this is due to a larger systemic and structural issue. The legal profession, which includes the bar and the judiciary, the legal profession is very patriarchal. It's a male-dominated profession. It has been historically, and so you really need to shake it up from its core if it has to be a space where there is fair representation and fair and equal representation for women, and also not just women, but women from all minorities and all other identities. So, the bar is just a reflection of that. I mean, you see that in the bench. You see, very little gender diversity in the bench. And similarly, you see that in the bar. And why is it happening? Because structurally, the profession is built like that. Why do you have lesser women arguing constitutional cases? Because where were women senior counsels, right? The senior counsel system itself just changed a few years back to an open application system, which has actually led to a large number of women lawyers becoming senior counsels. Before that, it was a closed door system. So you had only men who were becoming senior counsels. There were like less than 10 women senior counsels in the entire country. Karnataka had just one. So that opened up. Then even with senior counsels, it's going to take time before they get to be in the big cases. And what determines that? Your other structural decisions determine that. For example, who are the advocate generals? Who are the solicitor general? I mean, they argue the big cases. We've never had in 75 years a solicitor general who's female, an attorney general who's female, right? We've only had from 2009 additional solicitor generals who are female. And that was the first was Indira Jaising in 2009. I mean, so we don't have a single advocate general of a state, of any state, who's been a woman. So it is very, and these are the constitutional law posts where lawyers get to argue the big cases and get visibility and then build their repertoire. And so when you don't have women appointed at these positions, automatically the chances of them arguing big cases goes down. And then the judges don't give enough time to women counsels. Again, you have the bias and the sexism that is very deeply set in. So, all of that contributes. And so we really, if we want to see representation, whether it's representation of women in the bar, representation of women and lawyers from minority religions, from SC, ST, OBC communities, you really have to have a profession that is totally, turned out from its core. And how do we do that? I think some of these things are happening. We have changes made to advocate associations now, with the Supreme Court saying that there should be 30% women in bar associations. We need more of that across the board. So maybe that will slowly improve the situation.
And I think going forward, when we talk about equality and access, I think these are more important questions to also keep in mind, because they also play a little bit into who we're seeing up on these benches, right? And who's appearing for us. Aparna, I want to turn a bit to something that you mentioned in your book, which is the need for having norms to ensure accountability and transparency. Now, I know you've mentioned it in the context of case allocation, but also just to open that up a bit broader, what are the norms that you think the system can benefit from having to ensure some form of efficiency and transparency going forward?
That would depend, of course, on the function that we're talking about. The larger point that I was making in my book was that many of the challenges that we describe in our book, which is looking at sort of the administrative functioning of the court and how it's impacting its judicial decisions, would benefit from broad rule of law principles, right? Of just basic standards that the court holds any other public authority to. So, for example, collegium decisions, how are appointments made? I mean, I work in a public university. If my university were to appoint faculty using the same principles that the court, or the same structures that the court uses to appoint judges, we'd be dragged before courts, before the end of the day, and really face their wrath, rightfully so. But why is it that courts get away with it? But essentially what they're doing are appointing individuals to public posts, right? So what are the norms on that would be a very different question from what are the norms on case assignment that the Chief Justice does in their role as master of the roster. I think a larger point, though, is the need for the court to get away from this idea of judicial sort of exceptionalism, the idea that the judicial function is so distinct from all other public functions that it needs to be shrouded in mystery. And that mystique and that mystery is somehow important to preserve judicial independence. It is not. In fact, I think the evidence of the last few years at least has shown that this mystique and this mystery can end up both delegitimizing the court, right? Because in the vacuum that is created, other kinds of narratives fill in of why the court is making the decisions that it is making, but also obviously means that you have what other scholars have called like a single point of failure, right? If all this power is in the hands of one individual, and that individual is virtually unaccountable, not just to other individuals, but to principles, then we really have to trust that we'll get a Justice Lalit at some point who will do something right. And if we don't, then we just live with it, right? So that's the bigger problem that we were talking about. Specifically on constitution benches, I'll just reiterate the point that I was making and maybe take 30 seconds to explain what I meant, which is the idea of having a constitutional division which is focused solely on constitutional cases. That includes admission of matters. There might be matters which involve a constitutional issue that don't rise to the level of a substantial question of law as to the interpretation of a constitution. That could go before a two-judge bench. But those issues that have to go to a larger bench, go to a larger bench. There is enough and more work to keep that as an insulated element within the larger court structure, so that this entire deluge of SLPs that the court is currently facing doesn't end up impacting its constitutional function. And this might be an easier thing to do than to try and bring norms and structures and processes to the SLP system, because you would have to really fight the bar every step of the way. It is bread and butter of the bar. This admission getting sort of, what is the phrase that the court uses? Notice issued, notice issued, stay granted, right? Is where the big bucks lie. And making a change in that in the short term is not going to happen. So therefore, insulating the constitutional function so that at least constitutional decisions are being made on time, when it is of the moment, and not, 5 years after the world has changed. That I think would be a more immediate and a easier thing to do than struggling with the bar on the SLP front.
Right. And I think it's important for us to also think more about how we can bring these norms, like Jenna mentioned earlier. We also hear on a lot of these cases, once the interested people are no longer there or no longer in the same place that they were when they brought the case. So I think, yes, something to definitely think about going forward, right? And Nick, I just want to go back to you for one last question. You wrote your article over a decade ago on the quantitative analysis of the Supreme Court, and one of the things that you had mentioned in the piece was that there are a lot of deficiencies in data collection that make studying the institution itself difficult. But of course, since then, we've had more developments. We've had people who've looked at timestamps from, say, the display boards, or post-COVID, we've also had live streaming, we've had transcripts, and all of this has enabled some amount of data collection regarding the court. But do you think that what we have right now has helped bridge the gap a bit? And what do you think the Supreme Court could do differently or do more to encourage more research in this space?
Yeah, no, thank you. Yeah, no, I realized, which always makes me feel old, but I realized the other day that, I clerked for the Indian Supreme Court and for Chief Justice Sabharwal almost 20 years ago. So it's been a while. And the court is actually more open in certain ways, right? So there's the live streaming, there's the transcripts. None of that existed when I was, spending time there then. And I think that should be recognized, that should be applauded. And, knowledge is power, public knowledge, is public power in theory here. And I think the point is also, as you hint at, that not only is the data a lot better, or there's more data out there, but that's because there's more people working on this, right? So when I started kind of writing, it was like Rajiv Dhawan had done some work, that was really important. George Gadbois had done work back in the day, but there really wasn't much more than that. And now we just have a lot of different actors and players, right? There's VD, there's, the Center for Law and Policy Research, there's DOCSH, there's the Supreme Court Observer, there's Agami, there's PRS, there's legal academics like, Aparna, and, a bunch of other people writing on this. And as you said, there's just a lot more work coming out now about, even, the tracker you shared today about the number of benches pending, how long do they take to hear? None of that was there 20 years ago. And, I'd say that, but still, the court has its own data that my understanding is it's still not sharing, which is, what I had based some of that, initial writing on. And those were data sets that I got from the court itself. And this isn't the court's data, right? It's the Indian public's data, right? There's no reason this can't be shared. I pointed out there's some challenges with the data and how it's collected, and you might have some double counting. And I think, that's understood. Anybody who works in this understands, okay, just say clearly what you're collecting, what you're not collecting, and then share that, right? And put that data out into the public domain. And I think that could be really helpful. And then I just say, kind of as the last point here, gatherings like this are always encouraging to me. And when I talk to other people working on this, because it's about the data, but it's about something more. I often think about, there's Washington Post is a major newspaper in the United States, and there was a columnist, Robert Samuelson, who retired a few years ago, and he had a column for decades. And in his last column, he had this column in like maybe one of the most important papers in the United States, and he said, as far as I can tell, nothing I've ever written really had the slightest effect on anything that actually happened, right? And I think that's the kind of the silent fear of a lot of journalists and academics and others, right? We can analyze it, we can bring the data out, we can look at it, Vivek DeBroy, who passed away recently and also had worked in this space some, if you look at his last kind of Indian Express column and kind of self-obituary, he says something similar. But I think that's about, thinking about what's your broader strategy, right? And this has come up again, like the power of the BARD. What's your power mapping? How are you going to make differences? How are you going to capitalize on what feels like a real moment here, from my perspective at least, where the last couple Chief Justices have really committed into constitution benches and ensuring there's a constitution bench being heard. And now there's all these people working on the court and around the court. How do we keep that energy and power going to build this into something more, to solidify norms, to create what Aparna's talking about with a constitution division, or an admission bench or a standing bench, or whatever you want to do as your strategy, but building into that and building that power around. So I think it's important to get this data out, and should be public, and everything the court's collecting itself, shouldn't be a secret, and it should be able to come out. But it's also just as important, like exercises like this, of us coming together today, of you bringing people together, of sharing your research. I think that's really important and vital.
Thank you so much. I think that's definitely an encouraging note to wrap up our discussion with, and we have perhaps about 20 minutes for some question and answers. Maybe if we could open up and see if anyone from the audience has any questions, and we'll pass the mic around. Sorry, if you could just introduce yourself with your name and who your question is directed to, and keep your question brief, please.
Okay, sure. So my name is Keshav. My question is sorry. Can I just say my question? There was a point made on what is the whole purpose of the court. It was said that the Supreme Court was not meant to be for appeals, but not all cases have to be on these big issues of constitutional law. There can be much smaller issues which need the whole involvement of the court to sort of ensure that there is whole complete justice. So how do we sort of make sure that there is a balance and we don't lose focus on these smaller issues?
Should I just go ahead? Thanks for that question. I think that's a very valid question. And if you look at the Constitution, there are mechanisms provided for that, right? So you have, the court has an original jurisdiction, cases that can go directly to the court. That includes fundamental rights, that includes, federalism-related, state and center-related disputes, some others that go directly to the Supreme Court. Other than that, it has an appellate function where there are very strong filtering mechanisms, right? High courts have to certify that there's some larger issue here that requires the Supreme Court to hear it. As an exceptional, extraordinary power, and really because the Supreme Court was seen as replacing the Privy Council, a power, and literally in the Constituent Assembly they say, oh, we are setting up the Supreme Court and this is going to be our topmost court. How is it that it will have less power than the Privy Council? Our biggest court should have the most amount of power. And so, therefore, they put in this 136, the SLP clause, as an exceptional sort of catch-all phrase to say, okay, in those exceptional circumstances where these existing mechanisms don't work, you have some discretion with the court to take up those matters, right? Today, 88% of the court's docket is just SLPs. And Nick was mentioning, there have been studies done to say over 50% of the cases that the court is deciding in that route do not cite any law. and are in turn never cited again by the Supreme Court in the next 10 years. So what are those cases dealing with? They are cases that are dealing with pure factual matters, right? So I don't mean to say that the court should have no appellate function at all, but there needs to be some very strict controls on what are the kind of matters that go up before the court. Right? And there are easy wins here. For example, if all the lower courts have agreed on a particular outcome, chances are that the Supreme Court will agree on that with the lower courts, even if it admits the matter, right? In those cases, the court should be very skeptical of taking those matters in, right? The threshold should be much higher. Generally, we are seeing that that's not the case. The court is admitting these matters at the same rate as it admits a matter where the lower courts have disagreed with each other, right? They're not looking at whether this is a case where you need a new rule. This is a case where there's conflicting precedent. Those are not the concerns that the court has. The court's focus in this SLP jurisdiction is, did the lower court get it right? Do we think that the lower court got it right? It's not as if the Supreme Court is getting it right and saying that the lower courts didn't get it right. So which is the concern? And ultimately to say, the proof of the pudding being in the eating, of all these SLPs that the court does admit, it ends up reversing the lower court only about 56, 57% of the time, right? It's roughly for 50-50 odds that even after the court has admitted, it's done its admission after notice matter, done all of that, done the full hearing, it's only in about 50% of those cases and half of those cases that it finds that the lower court was actually wrong, right? So there's a problem with its filtering mechanism. That's the larger point.
Maybe we can take Alok and then we can come back.
Hi everyone. I'm Alok, one of the co-founders of Vidhi. Actually, I have just two short questions to Nick, and maybe Jyotika can supplement also. The first question was on the timeline for a case which got filed and how it went to the Constitution bench. And I wonder if this is something you explore in your article, which is going to be published. We find that there are certain cases which get fast-tracked, right? The 370 case, it may have taken 4 years, but it's still faster than the average. The same-sex marriage case, I think, was less than 1 year, if I'm not mistaken. Then there's another case which I've just forgotten about. But in contrast, I think the recent 9-judge bench decision in the Maharashtra Housing and Development Authority thing took like 20 years, and it's still not complete because they have to still place it before a smaller bench. I'm wondering if you saw any patterns in what seemed to be a basis for listing a case quicker or slower in the Constitution bench. And the second question that I have is the admission Constitution bench was a practice in the Supreme Court in the 60s. Chief Justice Hidayatullah describes it vividly in his book, My Own Boswell. And I think at some point it disappeared as a practice. So I don't know if you have discussed that in your article. Thank you.
Jyotika, do you want to take since you've been tracking all these, like whether there's certain cases that could move forward more quickly, or? I can also just start talking a little bit, because I haven't looked at this in detail, this part of, but, in earlier work, I've always said, the Supreme Court will sit on cases for years unless it wants to hear a case really fast, in which case it can hear a case really fast, right? And you see this particularly with the smaller benches, but the same logic applies, right? If there's a real kind of like political incentive to do it, then you can, there's no limits, right? Because there's no system in place right now for, that there's an order in which these have to be heard or anything like that. But Jyotika, did you want to?
Yeah, so I don't know if you can see me, but as Nick was saying, this listing of cases is not something that we have looked at in our article. But again, just to reiterate what he said, it's just, I personally feel like it's just cases where, there's a lot of maybe pressure in terms of like public pressure in terms of more people writing about it, maybe more people discussing the fact that, oh, this case has been pending for so long and the court is not listing it. So for instance, I don't think a case, I mean, these are important matters, for instance, the Maharashtra Housing Society, but it's not something, a case like, it's not a sort of case that will garner the attention that something like 370 does. So I think it's my personal interpretation that that's what happens usually. Thank you.
Yeah, and then I actually hadn't seen that. It doesn't surprise me that there was kind of a constitution bench admission system. I'll have to go and look that up, and so I appreciate that site. And that's because, right, that it was basically 5 judges and 3 judges at the beginning, right? And I think that's a couple points come out of that. One is back in the day, 3 benches was considered a weak bench, right? And then certainly in the 50s, 2 judges occasionally happened, but it was considered a very weak bench. And part of the argument of the article that Jayotika and I make is that one of the reasons you want larger constitution benches is to reduce the idiosyncratic kind of decisions of any given judge. And particularly on 2 judge benches, which are often led by the senior judge, you're really talking just about one judge deciding cases. And I respect all the judges, all of that, but people are going to have different levels of expertise. They're going to have their own kind of predilections, one direction or the other. And so larger benches are about bringing around kind of consistency and legitimacy and quality in terms of jurisprudence. And so I think it's important to think about that in the constitution benches, but also when we're thinking just about the purpose of the court, not to lose track of, oh, we just need more constitution benches, but what's going on with the 2 judge benches, right? And that was not originally envisioned. Maybe that's a smart choice, but it's I haven't looked systematically around the world, but it's an odd choice, right? Because it's an even number of judges, right? In a lot of places, it's 1 judge or 3 judges. But to have 2 judges, is that really an effective use of judicial time, particularly if it's the senior judge taking the lead? Either maybe you can strip it down to like high courts to 1, if you think that's the way to go, or you go to 3, right? But again, that's going to be a forcing function to hear fewer cases. And, as people have been pointing out, the bar doesn't get happy with that. But I think one of the things that is powerful about settings like this and everyone working on the court is we're not the bar, right? Like we're trying to figure out what's in the best interest of the court and what's in the best interest of the country. And so just focusing on that.
Thank you. There was a lady here who had a question.
Myself, Lakshmi N. I would like to pose my question to Jayana ma'am. So, ma'am, you mentioned about how there, in constituting a bench, a constitutional bench, there should be human intervention. And you also talked about the subject matter expertise, diversity, seniority, and tenure should be taken into consideration. But later in the part, you also mentioned about how there is a patriarchal thing at core when all these benches are constituted. Don't you think if it is done in a more the amount of rising technology that we have to put all the information of the judges into a app or something like that, it would give a more unbiased or more diverse bench rather than giving human intervention into it?
I mean, that's what technology says, that, you can, of course, feed everything and then it will come up with a combination, a different combination. But I do think that even keeping, to that extent, I do agree with Aparna that even if you take into account all these things, sometimes there has to be discretion to the Chief Justice as well to decide that for some reason I want someone else on the bench. And of course we need to have guidelines that these are not, that this is not done, to just skew and to bring about a certain result. But I don't think that everything can be put into a technological solution. Yes, you can put diversity, you can put age and seniority, you can put some of those things. But there's more to setting up a bench as well. So I feel that, and I feel the important thing is really to move towards a system where there is, the Chief Justice as the master of the roster publicly takes into account some of these things, and there are some guidelines that lay down that some of these factors will be taken into consideration. Today we have no guideline the master of the roster decides, anything without guidelines. So I think we need some norms, some openness as to how the benches are decided, how benches are constituted, how they will be constituted, some guidance which would be important to lay down. It's also important that the public knows what are the norms on which benches are going to be set up.
Thank you.
We have two questions. Maybe we'll take. I also have a question. Okay, we'll get Saurabh, and there's a gentleman at the back, and then we can have the panel answer both.
Hi, good evening. My name is Saurav. I work with Vidhi. I have two questions, and I'll be brief. My first question is pertaining to the timing that's given to a series of advocates while presenting the cases. So we see that there are taints of discrimination and sort of arbitrariness in the matter of how much time is allocated to a particular advocate. Do you believe that there is a right-based redressal to this problem? Second question being on the point of I would like to hear the comment of the panel on whether we should re-envision the whole role and the position of a Chief Justice as to whether they are appointed just based on their judicial making capacity or their seniority, or rather just their administrative capabilities. The context which I'll conclude within the next 10 seconds is that I believe in the early 1930s, Warren G. Harding was the Chief Justice of the Supreme Court, but he did not have much judicial expertise. Though his administrative capacities is talked a lot more because he was working with well-known judicial minds of that time, like a Justice Brandy or Justice Holmes. Do you think anything can work on that base? Thank you so much.
Can we just have that question as well, and then we can.
Thank you, madam. My question is to Jaina, madam. The omnipresence of Chief Justices, who are the master of roster, are first among the equals, who are deciding who should be in the Constitution bench. The moment there are some norms, so it is not always the master of the roster should be omnipresent on all the Constitution benches, and other senior most judges who are going to the part of collegium should be the moment they are given chance to lead the Constitution matters. Will it not be a way for the litigants, or for that matter for entire judiciary, to reduce the time that so-called Constitution benches are consuming?
I'll just answer maybe two parts, the first part of that question as well. I agree. I mean, I'll take your question. I agree that yes, while constitution benches have to be, set up so that the matters assigned to them are addressed and argued and decided. Also, there has to be some time frame to that. I do agree that whatever time frame, it can't go on for days on end. I think to some extent that is being followed now, that they are limiting the time. We see in many of the constitutional benches recently, they just kept 2 days or 3 days. So that is slowly happening, and I think that's a good result, and that should be followed. And to take your question, should there be time for the councils, right? You asked the question. What is the mechanism to have a redressal for this? I mean, the redressal, I mean, just off the cuff, I mean, what we tried to do in some of the recent constitutional bench hearings, for example, the marriage equality case, there were a lot of councils. I think it's important that time is given to all the councils, and it was really up to the councils to, to self, regulate and say, well, this is the most important argument that I want to make. I will take this much time. There was, the court appointed one council to kind of regulate that. It sometimes works, it sometimes doesn't. But at least an effort was being made. How do you ensure, I mean, we do have things like, for example, what often happens is, say the first 2-3 councils cover most of the questions. there's nothing left for the remaining councils to cover. But that's also not true. I mean, maybe the opening council could argue on Article 14 or 15(1) in a way which doesn't cover a nuance that another council down the line in seniority would like to cover. So I don't think it's, the court says, well, if you've covered these issues, don't raise anything new. No, but the other council may have an important, angle to cover, but time is important. So how do we ensure that if there is some uniform time, then there is some self-regulation, and at least that could be put in. I think it can start by the court saying, we will give this much time. And I think right now the court does something like, okay, we'll give equal time to petitioners and respondents. That always doesn't work, because if the respondent is just the union or just the state and there are far more petitioners, so, how can the court say we'll give this much time, maybe 2 days or 3 days to the entire matter? How many councils are there? Can we fix a timeline? The biggest challenge is putting a time restriction on the senior most councils. That's the biggest hurdle. Can you pin them down to a limited timeline? But I think that's slowly happening.
If I may, I think that goes to a question of what is the purpose of the oral hearing, right? If you look at our general advocacy culture, right, it's a very oral advocacy heavy culture, where everything that you write in your petition has to be spoken in court. Everything, your right to be heard includes this sort of right of an oral representation. And there may be good reason for it, but that obviously comes at a cost. And that's where I think the point that Nick was mentioning earlier, it's been discussed before, is, for example, should 2 or 5 working days be spent on hearing every matter that is filed before the court? I can take the most rubbish petition to the court, and the court has to give me even those 2 minutes, right, to at least hear that matter. And that's 60,000, 70,000 such matters over the course of a year. Are there things that don't necessarily, as a default rule, don't necessarily require an oral hearing, right? Can we move to documentary practices as a general standard? If that is the case, then what is the function of the court time, right? The court face time that you get with the judge. Is it to emphasize on the core points that you have and the clarify questions that the court might have? Or is it to expound on, my view of Article 14, for example, or, whatever it might be, anything and everything that I want to say that is already there in the petition, that will be repeated. I think that kind of a shift in thinking about the purpose of the oral hearing is something that we would have to move to eventually, right? It'll face a lot of resistance. Is it going to happen anytime soon? No, perhaps. But that is the kind of shift that is to be required, because otherwise, I would imagine any kind of time frame that you put in will structurally disadvantage those who are further down in the chain. Even as a client, I would want that the person who has the most influence with the court should be leading the matter, right? And regardless of whether they have the expertise in that particular matter. That is the view of, Kapil Sibal is representing, is arguing on my behalf, even if I'm not briefing him, even if he's not my lawyer directly, has some cachet. So all of that to say that I don't know that this kind of a system by itself will address the diversity question that you are leading to, or any of these time challenges of, this long expositions that happen in court that you will, that will be handled by this. On the question of who should the Chief Justice be, we've had a very, as you know, a terrible history with tinkering with the seniority norm. And I think that's something to be kept in mind, that at the very least, at this moment, of course, tinkering happens. Tinkering happens at the time of appointment, right? Who gets seniority, who doesn't get seniority, who will become the Chief Justice, who will not become the Chief Justice. But tinkering with that comes with its own costs. Ultimately, the Chief Justice is a judge, right? On the judicial side, technically, their vote is just one vote. Now, it's the administrative structure that they are part of that is allowing them to have a greater sway on the outputs of the court, rather than because they have some additional voice on the bench or additional votes on the bench. I would think, therefore, that at the first level, the judge has to be the Chief Justice has to be a sound judge. I would be very wary of thinking about efficiency as the driving element of judicial organization as opposed to justice and independence, right? So, I mean, those values are very important, and dare I say, when they are in absolute conflict and you have to choose between one or the other, it is justice and independence that should win out over efficiency. So that's a broader question to keep in mind. In terms of norms, there are different things that have been tried. In India, in actually 2018, after the judges' conference, there were 2 petitions that were filed in the Supreme Court. One said, have some kind of norms, open norms, publicly declared norms on how master of the roster powers will be used. The second said the collegium should decide how master of the roster powers will be used. The court rejected both and just reaffirmed the Chief Justice's master of the roster power. Pakistan, last year, Pakistan, they had a huge issue with the master of the roster. They brought in a new law, which their Supreme Court actually upheld, which creates a collegium to do this kind of allocation. Nepal has done something similar. So just in our neighborhood, the same kind of a problem with multiple benches and who does this kind of sensitive allocation, that there's a lot of churning that's happening. And maybe that's something that we should be looking at as well, comparatively.